Good morning, everybody, and welcome to this Office of Open Records webinar, the Right to Know Law for Requesters. My name is Erik Arneson. I am the Executive Director of the Office of Open Records, and I appreciate you joining us this morning. This webinar typically takes about 90 minutes. That includes plenty of time for questions and answers. And feel free as we go to type your questions if you have any in the chat box. I will take note of them there. Also with us today is George Spees. He's our Director of Training and Outreach. He does far more of these webinars than I do. So George is here to make sure everything runs smoothly. And he may also answer any questions that get placed in the chat window as well. Please be aware that we are recording this morning's session. I intend to post it to YouTube, and anything that is put into the chat box may very well be a record subject to the right to know law. And with that, we'll get started. A look at some of the basics of Pennsylvania's right to know law first. The basic process is pretty much exactly what you would probably expect it to be. A requester submits a request to a state or local agency. This law does not apply to federal agencies. There's a separate law known as the Freedom of Information Act that will allow you to request records from federal agencies. A request must seek records, not ask questions. And we'll get back to that a little bit later in the discussion this morning. The agency gets back to you. They can grant the request, deny the request. Often it's going to be a mix of both, partially granted and partially denied. And even if part of the request is denied, the requester can appeal. Usually those appeals go to the OOR, the Office of Open Records. And we issue a binding final determination at the end of the appeal process. After that, either side has the option to appeal our decision to court. It doesn't happen very often. As best we can tell from our data tracking, it happens less than 10% of the time, but it can. If it's a local agency that's involved in the appeal, any appeal from the Office of Open Records would go to the Court of Common Pleas. If it's a state agency, further appeal would go to the Commonwealth Court. A record is sort of the central element of Pennsylvania's right to know law. So it's important to spend a little bit of time understanding what a record is, even though it sounds very basic. But a record is any information that documents a transaction or activity of an agency. Doesn't matter what physical form or characteristics it has. Does it document a transaction or activity of an agency? That's really the central part of the definition. And the best court case we have that's fleshed that out a little bit is the one listed here, the Office of Attorney General versus the Philadelphia Inquirer from 2015. When Attorney General Kathleen Kane took office, she discovered a fairly widespread situation in the Attorney General's office involving the distribution of pornographic and obscene emails. She launched an investigation into that, and it was well covered in the media at the time. And one of the things that happened is that the Inquirer put in a request to see those emails, to see the original emails. And eventually the state Supreme Court ruled on this case. And the decision that came down was that those emails, offensive, inappropriate, they were done by government employees on government computers during government work hours. But nonetheless, they did not document a transaction or activity of the agency. So they were not records for purposes of the right to know law. When we wrote the law, when the law was written, I worked for Senator Dominic Pileggi. This was in the 2007-2008 legislative session. And we talked about this definition. And we were thinking about things like, an email that I might send to my wife and say, hey, I'm stopping at the grocery store on the way home. Here are the things that I'm going to get. Let me know if I should add anything to the list. We didn't anticipate this kind of a case, but this is the one that sort of gives us the outlines of what a record is in Pennsylvania. So that's something to keep in mind. Now, although the Inquirer was not able to get those emails With that request, I mentioned that Attorney General Kane launched an investigation. So that investigation, of course, did create a lot of records. Some of them were exempt because there are investigative exemptions in the right to know law, but eventually a lot of those emails came out because there was a report, there was a contract between the Attorney General's office and the investigating firm. So there were a lot of alternative ways to seek similar or even the same in some cases records. So sometimes if you are having difficulty getting a record that you're interested in one way, there might be alternative ways to think about putting in a request to reshape it, maybe send it to a different agency, that kind of thing. The right to know law does not distinguish between formats. It doesn't matter if the record is on paper, if it's an email, if it's on TikTok, it just doesn't matter. It also doesn't distinguish between agency devices and personal devices. So we often see cases in smaller communities where a township, maybe a school district, the supervising board, the elected board of school directors or the elected board of township supervisors, they just use their Gmail account or whatever separate email account they have because the agency isn't big enough to have its own IT department, for example. We see that pretty regularly. That might result in some practical challenges in accessing the records, but the right to know law doesn't care about that. It doesn't care if a record is generated on Gmail or the pa.gov server. It goes back to that test. Is it a record? Does it document a transaction or activity of an agency? And if so, is it a public record? And that's what we're going to spend the most time talking about here. All state and local government records in Pennsylvania are presumed to be public. All right, there are 30 exceptions in the right to know law that allow records to be withheld. And we're going to talk about the most common of those in pretty good detail later on. But what I want to emphasize here is that few of those exceptions apply to financial records and aggregated data, depersonalized data. So financial records in particular are the most public of records in Pennsylvania. If a record relates to an agency's finances, particularly its spending, that's the end of this that people are most often interested in. The right to know law's exemptions are probably not going to apply to that record. Sometimes other laws and regulations come into play. HIPAA protects certain healthcare records. FERPA protects certain education records. And there are plenty of other laws and regulations that come into play and interact with the right to know law. The right to know law defers to those other laws. So if another law says that something is not public, then it's not public. It doesn't really matter what the right to know law's exemptions say in cases like that. Attorney-client privilege is by far the most common privilege that we deal with in Pennsylvania. Doctor-patient can come into play. Other recognized privileges can also come into play occasionally, and we haven't seen it lately, but we have seen in the past on rare occasions that an agency would try to invoke something known as the self-critical evaluation privilege. It doesn't exist in Pennsylvania. It's a privilege that would, for example, I mentioned that George Spees from my office is here on this webinar with us. If George put an email together at the end and said, Eric, here are the top 10 stupid things you said during that webinar, and somebody then put in a request that would cover that, we could say, we could try to say, well, that's covered by the self-critical evaluation privilege. You know, that's self-criticism. It's not public. That does not fly in Pennsylvania. No Pennsylvania court has ever recognized the self-critical evaluation privilege. And until that happens, if it ever does, those records in Pennsylvania cannot be withheld under that privilege. Records, of course, can be made non-public by a court order. That happens from time to time. Now, when you receive a denial from an agency, and this is critical, the agency bears the burden of proof. That's a theme I'm going to come back to a few times here today, but it means that the agency has to demonstrate to the Office of Open Records why they are allowed to withhold that record. They have to demonstrate that one of those 30 exceptions applies to the record you've asked for, that some other law makes it non-public, that something in law allows them to withhold the record. They have to demonstrate that. You, as the requester, don't really have to demonstrate anything. When you're making a request, spend a little bit of time, again, very basic, but we see this mistake made often. Submit your right to know request to the correct agency. You want to make sure that it's the agency that's most likely to have the records you want. At the Office of Open Records, we probably get more misdirected requests than any office or agency in the state. Because of our name, a lot of people assume we just have the records. We don't have the records. If you want our records, put in a request and we'll process that. But every year we receive more than 900 misdirected requests, people looking for records from other agencies. This year that number is already over 1,000. So be sure to put in a little bit of upfront research to make sure you're going to the right agency. It's going to save you a lot of time. Address your request to the agency open records officer. If you don't know who that person is, you can just use that title, agency open records officer. That's absolutely fine. We do have a database on our website. That's the search tool. You can see it there on your screen. Very simple. You can search by agency name. You could search by county. You could list every agency in a particular county if that's the only field you fill in. For example, an agency type, state or local. So before you file a request, use that database. It's not perfect. There are about 6,000 agencies in Pennsylvania. We have 500 school districts. We have 67 counties. And then we have thousands of municipalities, townships, boroughs, cities. We also have authorities. Sometimes police departments are separate agencies. Sometimes they're the same with the township or the borough that they serve. So using that database is the best way to get to the person you should get your request to. It's not perfect, but it is constantly updated, and it's the best single source of that information that I'm aware of. And again, if all else fails, just use the title, Agency Open Records Officer. And the acronym for that, AORO, we always pronounce ARROW. So if you hear me say ARROW, I'm talking about Agency Open Records Officer. Most agencies have just one person in that job. Commonwealth agencies are a great example of this. The Department of Environmental Protection, Department of Conservation and Natural Resources. If you want to request a record from a state agency, it's usually very easy to find. Most state agencies do a fantastic job of making their information easy to find, and you can get it to the right person. Some agencies have separated their arrows by bureau, by division, by department, etc. Philadelphia, for example, very large city, the largest in the state, of course, has about 40 arrows. And they also do a great job. They have a single PDF document on the city's website that lists who those 40 people are, lists their contact information, what bureau or division or department they're involved in. And so they make it very easy for you to find the right person to send your request to. If you don't know that you're sending it to the right person, I always recommend just put a sentence on your request that says, if this is misdirected, please let me know so I can withdraw it and direct it to the proper arrow. By withdrawing the request, you're going to save the agency the time of having to go through the formal response that the right to know law requires. And so by letting them know that you're willing to do that, if it's misdirected, usually it will save you time. They'll get back to you quickly and tell you that they don't have the records, but you might want to try X, Y, Z. Some basic steps in filing a right to know request. First, I encourage you to remember this is not intended to be used as a weapon. The right to know law works best when both sides are working in good faith. And in the overwhelming majority of cases, that's what happens. There are certain circumstances where somebody might get extremely frustrated with their local municipality or some other agency. And because of that frustration, submit dozens of requests. And it's not always wrong to submit dozens of requests, but if the motivation for doing that is to gum up the works, to get back at the agency for some slight, whether perceived or real, that's not what the right to know law is intended for. It does not work well when that happens. So just a note of caution on that. Be sure to use the appropriate form to request records. We have a standard request form available on our website. It's available in Word and PDF. The PDF is fillable. Every agency has to accept that form. Agencies are allowed to accept right-to-know requests that are not on a form, but it is also permissible for an agency to establish a policy that requires a form. And that kind of information should be easy to find. It's not always easy to find. The safest thing to do is to use the standard request form available at our website. And if you have any issues using it or even finding it, let us know and we'll be happy to point you to it. If an agency has its own form, the right-to-know law allows them to develop their own forms. If they have one, strongly consider using that because it might be more tailored to the kind of records that that agency keeps. Be specific. We're going to spend a good deal of time talking about this morning because specificity is absolutely critical in Pennsylvania's right-to-know law. Be specific when you're describing the records. We'll get into all of that detail later. Always note the date that you send in a request. There are some extremely inflexible deadlines in Pennsylvania's right-to-know law, and so it is important that you, the requester, keep track of things as they move forward in the process. Here's a look at that form that's on our website. This is the PDF version. I've broken it into a couple of slides just to highlight a few things very quickly. Up at the top, just note what agency you're submitting it to. You can see that we have right there on the form, attention arrow. So we've already addressed that in a way. If you know the person, you can go ahead and include that there as well. Be sure to include some information about yourself. Specifically, this underlined question: how do you prefer to be contacted if the agency has questions? Telephone, email, or US mail? Communication between requesters and agencies is really important when you're submitting a right-to-know request. Often requesters will submit a request and they don't really speak the language, the lingo, the jargon of the agency. And so they're trying to describe the records they want. And when the agency receives it, speaking a slightly different language, they might interpret it far more broadly than the requester intended or far more narrowly than the requester intended. So just making it clear to the agency that you're willing to have conversations about that kind of thing is very helpful. And then here under records requested, all that italicized type there, those are tips that summarize kind of in a way what this entire webinar is about, designed to help you put together a good request that will get the records you're seeking. You'll also be asked if you want copies of the records, and there's 3 choices on our form. Electronic copies are preferred if available, or printed copies are preferred, or in-person inspection of records is preferred. And if you do that, you can request copies later. In-person inspection, that doesn't happen too often, but it will require you to set up a time that is mutually agreeable between you and the agency for you to go in and actually inspect the records in person rather than receiving copies. Sometimes that might help avoid certain costs under the right-to-know law, but particularly in the world of COVID-19 and this pandemic, in-person inspection of records is reduced, and it was never really the biggest method of obtaining copies in the first place, or of reviewing records in the first place. So if electronic copies are available, they can send them to you that way. If you prefer printed copies, just let them know. You're also asked here if you want certified copies. You do not want certified copies. An agency can charge additional money for certified copies, and really you only need copies to be certified if your request is involved in some kind of legal situation. If there's a lawsuit going on that you need the records for, maybe they need to be certified, but typically records do not need to be certified. And we also have a line here where you're able to ask the agency to notify you if any fees associated with the request would be more than $100, or you can fill in whatever amount you want. Again, that's designed to encourage communication, to make sure that requesters aren't hit with surprise bills for right-to-know requests, and to make sure that agencies don't do a lot of work and then send out a notice to the requester who says, whoa, I had no idea it was going to cost that much. I'm not interested. So always fill that in. Whatever amount you think is reasonable given the request that you're making is fine. It's really just designed to encourage communication. And then there's a lot of stuff at the bottom of the form that the agency uses to track the request and that sort of thing. All right, so you send in a request. The agency has to get back to you within 5 business days. If they don't, the request has been deemed denied. I'll use that phrase sometimes. It really has no legal difference between deemed denied and denied. There's no difference between the two. But if you don't receive any response within that time frame, it's been deemed denied. We do ask you to allow 3 additional days. Some agencies prefer to send responses by postal mail. So if you receive something in the US mail a few days later, but it was dated within those 5 agency business days, then it's a timely response. The agency can extend the timeline by 30 calendar days. If they do that, they have to do it in writing and they have to tell you about it within those initial 5 business days. So one way or another, you should hear something from an agency within 5 business days. If you don't, the request has been deemed denied. Now, I clarify at the top there that it's agency business days because not every agency in Pennsylvania is open 5 days a week. Most are, the vast majority are, but there are situations, again, typically in smaller communities where a township office or a borough office, for example, might only be open 4 days, 3 days, 2 days a week. Sometimes school districts over the summer have alternative hours where they're not always open 5 days a week at that time either. Again, track all dates and deadlines in case you need to appeal. And also note that any extension beyond the 30 calendar days must be agreed to by you, the requester, and that has to be done in writing. We see situations sometimes where an agency reaches out to a requester, calls them, and says, hey, we need a little bit of extra time. We need another 3 weeks beyond these 30 calendar days that we've already taken. Is that okay with you? The requester says, yeah, you know what? I appreciate you working on this. That's great. Go ahead. But it's never put into writing. And then the request is partially denied, for example, and the requester wants to appeal that to the Office of Open Records. But because that second extension was never put into writing, the law is written in such a way that we just don't have the flexibility right now to hear that appeal. So track those dates and deadlines. Make sure that anything dealing with a date or a deadline is done in writing. And when I say in writing, email is fine, of course. But just make sure it's all documented in something that can be sent to the Office of Open Records for our review. I do support an amendment to the law, which has been introduced in the General Assembly a few times to make that a little bit more user-friendly. But at this point, that's the status of the right to know law. Here's a quick example. Oscar Olson is my great-grandfather. He was not alive in 2019, but if he had been, let's say that he made a request to an agency on August 1st of 2019. That's a Thursday. The agency takes a 30-day extension that goes to September 7th. Turns out that was a Saturday in 2019. So the deadline moves to Monday, September 9th. Everything's being done by email. September 12th, the agency emails, asks for another month. Oscar, being the friendly fellow that he was, he says, great, that's no problem, that's fine. October 1st, the agency issues its response, partially denies it. That same day, he's on the ball. Oscar files an appeal with the OOR. Unfortunately, you see the problem probably. The deadline was Monday, September 9th, and the agency didn't reach out until September 12th. And so the request was deemed denied on September 9th, which means that the appeal, you have 15 business days to file an appeal after your request is denied or deemed denied. In this case, an appeal had to be filed by September 30th. So we have no choice but to dismiss this appeal as untimely. It's probably the most frustrating thing we do. We'd much rather get to the merits of every decision that we have come in, but we really don't have a choice. So again, I'll stop pounding on it so hard probably now, but track your dates and deadlines. All right, how much is all this going to cost? We have a fee schedule that's developed pursuant to the right to know law. It's available on our website. We are currently in the midst of reviewing that fee schedule. The right to know law requires the OOR to do that every 2 years. And so within the next, by the end of this month, we'll have an update to the fee schedule. But I don't expect dramatic changes to it. So these basics will probably still be in place. There's no charge for electronic records. If you ask for emails or memos, anything that exists electronically, and they can provide it electronically, there's no charge for that. The one exception is for agencies that require printing out records to redact them securely. We had a case where an agency had been providing records to a requester. I think it was on a quarterly basis. And the agency had been providing them electronically. It had been going on for some time. Then the agency shifted to providing them in print. They printed them out and they made the redactions and they provided them that way. They may have actually scanned them back in at that point and provided them. Previously, they had been doing electronic redactions. And the requester appealed to us and said, hey, we're not questioning the redactions, but previously the redactions had been done electronically and they were providing the records electronically, so there was no charge. That's how they should continue providing us these records. The agency was able to demonstrate during the course of that appeal that the requester had been able to undo the electronic redactions. And so they felt that in order to do their redactions securely, they had to print those records out. They found this out, by the way, by the fact that the requester was posting the unredacted versions to a website. And they discovered that and saw what had happened. So we ruled that if the redactions are appropriate, and they were absolutely appropriate in this case, then the agency has the ability under the right to know law to do what it thinks it needs to make sure those redactions are secure. And so we allowed the agency to charge for the pages that had to be printed out to perform those redactions. And agencies can charge up to 25 cents a page when hard copies are a necessary part of a response to the right to know request. Requesters can photograph records they ask to inspect. So getting back to that inspection issue, again, this will be more relevant once we're beyond the broad impact of the pandemic. But if you go to inspect records, you can photograph them. I should point out as well that the right to know law, I said it applies to all state and local agencies. That's generally true. Judicial agencies are a little bit different and often have their own rules and have their own processes for requesting records. So if you're looking for records from a judicial agency, such as a clerk of courts or a prothonotary, or directly from a judge, something like that, it's a different process, and you should look for Rule 506 on the Pennsylvania Supreme Court website. Typically, financial records are available through that rule. Other records, such as case files, et cetera, they're more available under common law, and you will typically need to go into the office. Some counties have records available online. That varies by county. It varies by record type. So if you're looking for judicial records, just be aware that it's often a very different process than the one that I'm describing today. And they might have different rules, for example, on whether or not you're able to photograph records in their offices. Agencies do not have to create a record. We're going to talk about that more in a little while. But they are required to provide the records in the medium requested, which really is just the difference between electronic and hard copy. If an agency denies a request, it must put that denial in writing. It must explain what records are being withheld, why they are being withheld, how to appeal the denial, And if they fail to respond by the statutory deadline, of course, we've talked about this, so you already know it, that is a deemed denial, and it can be appealed just like a regular denial. Now, sometimes agencies don't do all of this when they send you a denial. They should, and we, in our training for agencies, emphasize that fact. But even if they don't, it doesn't change your right to have an appeal under the right to know law. You can still appeal any denial. Most often, you're going to appeal that to the Office of Open Records. All right, some practical tips here on writing good right to know requests. First, seek records, don't ask questions. We talked about this at the very start, and it is good to reiterate. The right to know law gives access to public records. It's not an interview situation. So if you put in a request that says, why did the chairman vote yes? You're probably not going to get anything in response. Instead, request the meeting minutes, request an audio recording of the meeting if it exists, things like that. If you want to know why company X received a particular contract, asking that question probably won't result in anything, but you could request copies of all submitted bids. You could request copies of emails related to the contract or related to the company. Those are ways to get the information you might be seeking, but don't ask questions because agencies may deny requests which ask questions. Specificity is determined on a case-by-case basis. I'm going to spend a decent amount of time on this because it's very important in the right to know process. The primary goal of your request is just to have the agency understand what you're looking for. But vast fishing expeditions are not permitted. I'll talk about that in a second. And phrases like any and all and but not limited to, those are things that we often see requesters use, but they tend to raise more questions than they do to be helpful. We often see it from attorneys who are used to a discovery process, and those phrases are, as I understand it, helpful in the discovery process, but not really so much in the right to know process. So if you submitted a record that said, I'd like any and all records, including but not limited to emails, memos, and spreadsheets about the 2019 Pine Street Bridge project, what you're really going to get are emails, memos, and spreadsheets about the 2019 Pine Street Bridge project. Anything outside of that is probably not sufficiently specific under the right to know law. And if you just say, I want all records relating to the 2019 Pine Street Bridge project, again, that can be not specific enough. It's always good to include things that you are specifically interested in, emails, memos, spreadsheets, etc. Now, all of that said, poor organization of records is not held against the requester, and we'll talk about that more in just a second. Here's an example of what I would consider to be a pretty good request. Upper Smith Township replaced the Pine Street Bridge in October of 2019. I'm seeking the following records about that project. I want emails from a very specific date range. Whenever possible, with an email request, list senders and recipients. The bigger an agency is, the more important it is to do that. If an agency, has 3 or 4 employees, you might not need to do that. But if an agency has thousands of employees, being able to focus on specific senders and recipients is very important. I'd also like memos from a particular date range. And this is all, of course, about the Pine Street Bridge project. It was replaced in October 2019. We know that because of the umbrella language at the beginning. I want invoices from the year 2019. And I want all records of disbursements during calendar year 2019. Always a good idea to add at the bottom of your request, please contact me with any questions about this request. Again, communication, absolutely critical to the right to know process. Specificity is a 3-part test in Pennsylvania. This was fleshed out in a case known as the Department of Education versus the Post-Gazette. You want to identify a subject matter. That's the transaction or activity of the agency. Remember what a record is. Any information that documents a transaction or activity of the agency. So you want to identify that transaction or activity. What's the subject matter of your request? Scope. This is where you talk about emails, memos, letters, texts, videos, photographs, whatever it is. The type of the record, the recipients, the senders, that all falls under scope. Be sure to include a good scope. And time frame, it's good to identify a finite period of time. And we see sometimes that the time frame becomes the most critical part of the specificity test. Sometimes it's the least important part. That's why we describe it as the most fluid factor. Sometimes it can be implied, such as the ongoing Main Street repaving. Everybody knows when the Main Street repaving project began, so there is a time frame that can be implied by using that kind of phrasing. Here's the case that spells all this out. It was a request by the Post-Gazette seeking all emails from the Acting Secretary of Education, all emails as they pertain to the performance of her duties. So you weren't looking for the grocery list. You were looking for everything about the performance of her duties from basically, it was over a year-long period. The court found that that is insufficiently specific because by virtue of the secretary's position, a request about all of the agency's activity over nearly a one-year period is a fishing expedition, and therefore it is too broad. So all emails over a year, that is too broad. The Department of Environmental Protection versus Legear. This was a request for 4 years of Section 208 determination letters. Those are letters that DEP sends to the operators of certain wells when there are issues that need to be resolved. And the department said, we have these letters, but we don't organize them chronologically. And so we think this request is insufficiently specific. If we had well operator names, if we had some more information, we'd be able to find these records and provide them, but as written, it's insufficiently specific. The court disagreed. The court said that it is sufficiently specific and that the fact that the agency chose to organize its records by well operator or by some method other than chronological date is not to be held against the requesters. So an agency's organizational decisions, and we encourage agencies, of course, to think about organizing their records in ways that make it easy to respond to right-to-know requests. But from the requester perspective, that is not something that gets held against you in the right-to-know process. And also on specificity, the Department of Corrections versus Amanda St. Hilaire. She was a reporter and she sought all records, a very broad phrase, but she wanted them documenting inmate injuries or deaths over 5 years at state correctional institutes. The court held that that is sufficiently specific, even though all records was broad. The subject matter was very specific. The Department of Corrections obviously knows what's going on at state correctional institutes with regard to injuries and deaths. And so the court held that those records do need to be provided. Again, I encourage you not to use the phrasing of all records, but it is not 100% fatal all of the time. Always better to be a little more specific though. Beware of using only keywords. Keywords can be very helpful, especially when you're asking an agency to search its email, but beware of using only keywords. You still have to identify a transaction or an activity of the agency. The case that we always look at for this was a request for all emails from the governor's chief of staff over a period of about 6 or 7 months. The court found there that it was a sufficiently specific request and it involved only keywords, but there had been a lot of dialogue back and forth between the requester and the agency as to what those keywords were about and stuff that was sort of outside of the official request itself. And so using broad keywords is not a good way to go. We've seen these are not all specific real examples, but they're all based on real examples. Emails from Erik Arneson that contain the keyword Arneson. That's just another way of asking for all emails, right? Emails and texts containing concern, concerning, complaint, complaining. What's the transaction or activity of the agency there? If you want records about all of the complaints that were filed with an agency on a specific topic or about a specific person or something like that, say so. This kind of approach is very unlikely to result in a successful request. We saw a request, this is a real one, for emails containing the, it, is, and again, that's just a way to try and ask for all emails without asking for all emails, but it doesn't work. So keywords can be helpful, but relying on them alone is a risky proposition. I think it's most useful to think about keywords in this context. If you add at the end of a request something like, one way to satisfy my request would be to search Jane Smith's emails for the keywords John Doe and suspension, or something like that. So structure your request normally using all the principles we've talked about before, but then add an example at the end of something that you think would be useful to the agency to do. Be careful about requesting lists. If a list doesn't exist, the agency isn't required to create one. So if you say, I'd like a list of all lawsuits filed against the agency in 2017, or I want a list of all properties with zoning violations over a period of time, if that list doesn't already exist, the agency isn't required to create it. It's better to seek the records containing that information and to use that word, records, showing the captions of lawsuits filed against the agency in 2017, records showing the zoning violations. Of course, you can always add, if this information can be provided in a list, that's how I would prefer to receive it. That way, if the agency has a list, they know that's what you're really looking for and they can provide it to you. Now, sometimes agencies will create a list. We encourage agencies to use common sense, of course, when responding to right-to-know requests. And sometimes it's much easier to create a list than it is to provide all of the records that would be required to create that list. But they're not required to create a record that doesn't already exist. It might make sense for them to do it. We encourage them to think about doing it, but they're not required to do it. Related to that is accessing information in databases. So if a list doesn't exist, but the information is contained in a database, you might be able to get to it from the database, because extracting information from a database is not creating a record. The case law on that is extremely clear. Information in databases is subject to the same presumption of openness as any other government record. Database entries, database data does not have any special standing under the right-to-know law. If you can, it's good to learn about the capabilities of the program or the database that the agency is using. Sometimes they use custom databases. Sometimes they use databases that are commercially available. You might be able to watch YouTube videos from the company that provides the database, explaining how it's used, explaining what its capabilities are. Those are all very smart things to do before submitting a right-to-know request. Technology or terminology, can be important. Using agency jargon, if possible, if you know what you're talking about well enough to do that with confidence, that can be a good idea. Suggesting queries can be helpful where relevant. They may be necessary for extracting information from the databases. That's a very common way for information to be pulled from databases, and that can help focus the agency searches. Queries, very similar to keywords. Be sure you identify the transaction or activity of the agency before you do that. Relying only on a suggested query, which can look like a very technical kind of phrasing, can be risky. It can lead to a denial because you might have not identified a transaction or activity of the agency. So remember, the right-to-know law requires specificity, and the first step is always identifying a transaction or activity of an agency. couple of quick cases here to point you to on databases. Gingrich versus the Game Commission. Records related to deer harvest and habitat were requested here. And the court was very clear that requesters may provide suggestions or examples, that there's no reason, no desire on the part of the court to discourage that practice, and that providing data from a database does not constitute creating a record. Also in 2012, in a separate case, the Commonwealth Court held that to the extent requested information exists in a database, it must be provided. To hold otherwise would encourage an agency to avoid disclosing public records by putting information into electronic databases. So case law is very clear, very strong, that information in databases is available, subject to the same exemptions, subject to other laws potentially making it non-public. All of the same rules apply, but information in databases does not receive any special protection under the right to know law either. This is still a developing part of the law. We're seeing more and more database related cases come through the Office of Open Records in recent years. Here are a few examples from a few years ago. In one, the OOR held that an agency may be made to prove that a query was properly structured to reveal all potentially responsive records. These numbers on the screen here are case numbers at the Office of Open Records. If you go to our website and you use the docket search function, you can search on those numbers. You can also link to them. This presentation is available on our Open Records Pennsylvania blog, and you can download it and just use the links as well. In that second case there, being overly specific, we want you to be very specific, but being overly specific can sometimes be damaging. In that case, the requester very specifically said, I want these records in TXT or CSV format. Those are the only two acceptable formats. It was a proprietary database that was at issue, and the agency was able to demonstrate to us that the only output function that that database had, I don't know why they designed it this way, but they did. The only output function was PDF. And so the agency denied the request because they couldn't provide TXT or CSV. We had to uphold that denial. Now, of course, the requester could go back to the agency and request those same records in PDF format. But because they had so specifically sought TXT or CSV, it slowed things down. And speaking of format, the law currently only specifies medium, which is electronic versus hard copy, mentioned that earlier. In these two cases, we see that providing a PDF file, even when comma or tab delimited data was sought and is technically available from the agency, that right now the status of the right to know law is that they can provide it in PDF. The requester sought electronic, PDF is electronic, they can do that. Again, we encourage agencies to think about using common sense there and providing it in the format that was requested. But right now, the law only requires medium, not format. Again, there is legislation pending to change that, which I support, but that's where we are right now. Now, we have held that if a native PDF can be created, that is essentially file save as PDF, that if that is available, that the records must be provided in that format as opposed to a scanned PDF. We had a case here where the agency had printed out the records and scanned them back in as a PDF rather than just saving it as a PDF. And of course, a scanned PDF is much less functional, much less useful than a native PDF document. And we held that the records had to be provided in the native PDF format. Speaking of databases, two good ones for you to be aware of. The Pennsylvania Treasury website has an online contract database. All state agency contracts of $5,000 or more are listed there. Many of them are instantly available for download. You can search by agency, by contractor name, by date range. There's a lot of functionality there. So if you're interested in state contracts, that's a great place to go. PennWatch, if you're interested in state employee information, names, titles, salaries, state agency employee counts, that kind of information, PennWatch is the place to go. It also has some basic state budget information, but the Office of Budget website is a much better resource if you're interested in state budget information than PennWatch. But if you want employee level information, PennWatch is the place to go. All right, we said earlier that there are 30 exemptions in the right to know law. And these are the 7 that we most commonly see during appeals in front of the Office of Open Records. This data is from 2018. It did not change in any significant way in 2019. And from what we've seen so far in 2020, I think this list is going to be pretty much the same. I don't have them ranked here in order of how often they were used. You can see that information in our annual reports. Here, I just listed them mostly in numerical order of the section of the right to know law that is referenced. I flipped non-criminal and criminal investigation because I have a lot more to say about criminal investigative records, and we'll get to that in a minute. So I'm going to talk about each of these briefly so you understand what they are, because they are the most common reasons for denying records that we see. And by the way, all of these exemptions are reviewed in great detail in our Right to Know Law Case Law Index. It's a document that we put out earlier this year, more of a book really, that we put out earlier this year. It has information about key appellate court decisions, so decisions from the Commonwealth Court and decisions from the Supreme Court about the right to know law. Each of these exemptions has its own section. Some of them are much longer than others. These most common ones we see tend to be the longer sections in the case law index. And it is available from our website at that link there. It is our About the Right to Know Law and Frequently Asked Questions page. So very easy to find and download. We update it regularly as new cases come out. All right. So the first exemption I'll talk about is Section 708B1. It's the personal security exemption, and it allows agencies to withhold records reasonably likely to result in a substantial and demonstrable risk of physical harm to an individual. Agencies have to provide more than mere speculation to use this exemption. They have to show that the disclosure creates a reasonable likelihood of harm. Now, a prison setting, which is often where we see this exemption come into play, does involve unique concerns and security risks. That's a quote from a Commonwealth Court decision, I believe it was. And that's something that the OOR always takes into consideration with requests related to prison records. Section 708B2 is the public safety exemption, and it allows agencies to withhold records reasonably likely to jeopardize or threaten public safety or preparedness. We often see this cited in conjunction with the personal security exemption, but they really are 2 separate exemptions that cover different kinds of records. In the case that I have linked to here, again, that's an OOR docket number. A request was made related to surveillance cameras in Allegheny County. And we held that the agency could not withhold vendor names and it could not withhold types of surveillance cameras purchased. That the agency did not demonstrate that disclosure of that information was reasonably likely to jeopardize public safety. But we did say that the agency could withhold the specific locations of the cameras. The agency was able to demonstrate that in previous situations where the specific location of surveillance cameras became known, that they were subject to much higher rates of vandalism, for example, and that not all of the cameras were necessarily visible by people just looking around, that some of them were camouflaged or disguised in some way that made identifying their location visually difficult. So that's what the Office of Open Records held. The Court of Common Pleas disagreed. They overturned us. They said that the agency can withhold all of those records. Unfortunately, it was just a 1-page order, so we don't have any insight into the court's thinking there. But the decision has been appealed to Commonwealth Court where it is currently pending. The personal identification exemption allows agencies to withhold basic information about employees: social security numbers, driver's license numbers, personal financial information. All of these things, for the most part, I think are the kinds of things you would think about personal information that should probably be exempt from right to know requests. Email addresses and personal telephone numbers. That even includes agency issued telephone numbers and email addresses, unless those things have been held out to the public. But if there is an email address that is used, even if it's a, for example, pa.gov address, what we use at the Office of Open Records, if it's not held out to the public, the agency is not required to disclose it in response to a right to know request. Marital status, spouse's name, etc. The home addresses of judges and police officers can be withheld and do not need to be disclosed in response to a right to know request. Agency employee information is also covered by B7. B6, I think I've said that that applies to agency employees. I should not have said that. It applies to all records. If an agency has a record that relates to a private citizen, B6 applies to that just as much as it does to agency employee information. This one is specifically targeted to information about agency employees, information regarding discipline, demotion, or discharge. This is the part of this exemption that we deal with the most. So that information can be withheld except the final action of an agency that results in demotion or discharge. So you might not be able to get a lot of details about why a particular agency employee was demoted or was discharged, but the fact that the employee was demoted or discharged is always going to be public record. Other things that can be withheld relating to an agency employee include civil service test results, performance ratings, grievance material, written criticisms of the employee, and employment applications of someone not hired by the agency, which of course implies, and it is in fact the case, that applications of someone who was hired or of people who were hired by agencies, those are generally speaking available via right to know request, potentially subject to some redaction. For example, some of that personal information we talked about on the earlier slide may be redacted. All right, internal predecisional deliberations. Under section 708B10, agencies can withhold internal predecisional deliberations. So they have to be internal to the agency, they have to be made prior to a decision, and they must be deliberative. What does all of that mean? Typically here, what we're talking about are emails. And we're talking about emails going around to a group of agency employees that might say, for example, I really think it's time to put a roundabout in Lower Allen Township, and I think that it should go here. Here are the 4 alternatives we've talked about. I know that some people think those are good, but here's why I think they're bad, et cetera, et cetera. That kind of internal predecisional deliberation can be withheld under the right to know law. And the concept behind this exemption is that agency employees should be able to have free and unfettered discussions about important policy decisions without having to sort of be concerned that if they have a dumb thought in there somewhere, that it's going to be made public. Now, important to note, however, that factual information cannot be withheld under this exemption, even if the surrounding material has to be redacted. So, continuing that example that I used of the roundabout, if there are traffic study numbers that get put into that email, or a tabulation of, we heard from 142 residents and here are the results, and it's laid out in a table, for example, that kind of information is generally going to be public. Factual numerical data type of stuff cannot be withheld under this exemption. The non-criminal investigative exemption, I'm going to talk next about the criminal investigative exemption, but there's also a non-criminal investigative exemption, and that covers investigations by agencies that aren't criminal in nature, obviously. What are those? Those are things like an inspection to see if somebody's operating a well properly, for example, or to go and examine something that was alleged to have happened with a sports team at a school, for example. Things like that tend to fall under the non-criminal investigative exemption. And so agencies can withhold investigative notes, correspondence reports, the identity of confidential sources. They can withhold work papers underlying an audit. Sometimes audits qualify for this exemption, but the final result of the audit typically is going to be public. And they can also withhold records that would reveal the institutional progress of an investigation, except for the imposition of a fine or a penalty. So that's always public, the imposition of a fine or a penalty. The suspension, modification, or revocation of a license, a permit, etc. That is always going to be public. And executed settlement agreements, those will always be public unless they're made confidential by a court. We see sometimes settlement agreements when, for example, a superintendent is leaving a school district. There might be some sort of settlement agreement between the superintendent and the district. Sometimes those settlement agreements include language that says this agreement is confidential. The agreement is not confidential unless a court says it's confidential. Under the right to know law, you can make a request for it and they have to provide it to you. Often that kind of phrasing is, I think, designed to give the parties some time, because right to know request, we talked about the timeline earlier, it's not instantaneous, and so it gives people a little bit of time. But the settlement agreement, it's public, unless a court says that it is not. All right, let's dig into criminal investigative records a little bit. Under this exemption, agencies can withhold a lot of the language mirrors what we just talked about: investigative materials, notes, correspondence, reports, videos, etc., confidential sources. They can withhold victim information. They can withhold records that would reveal the institution or progress of a criminal investigation, except they cannot withhold the filing of criminal charges. We're going to talk about that in a bit. And they can withhold records that would hinder an arrest or impair the ability to locate a defendant. What this exemption does not allow agencies to withhold are very specifically two things. Private criminal complaints, those are public. It's a bit of an oddity, but Pennsylvania law does allow for private criminal complaints. Typically, those are going to be held by a county district attorney. If you're interested in one, that's where you should direct your request. Those are public. And police blotter, public. It's a very wonderful old school term. And if you want police blotter information, it is always good to use that phrase, police blotter. And what it means is a chronological listing of arrests, usually documented at the time of the incident, including the name and address of the individual charged and the alleged offenses. In other words, we don't have secret arrests, right? If somebody has been arrested, the public has a right to know who was arrested and what the charges are, at an absolute minimum. And so if you want information about a specific incident, a specific arrest, or you want to say, I'd like to see your police blotter information for this time frame, those are things that you can get under the right to know law. Now, records related to police agencies that may not be investigative in nature, but which we've seen interest in over the years at the Office of Open Records, include training records and policies. And those are often public, at least in part. Police department policies, such as department-wide training requirements, are generally public. Some policies may be redacted, such as if you have a police agency that has a SWAT team and they have a manual that lays out how they're going to respond to certain situations, a lot of that tactical information can be withheld. It would be reasonably likely to endanger public safety if that information became public, because it would allow bad actors to plan knowing how the SWAT team was going to respond, for example. But often those records, at least in part, are available to the public. Individual officer training records may also be available. In April of 2019, the Bucks County Courier-Times was able to obtain records that showed that a police officer who shot and wounded a man after he confused his stun gun with his Glock 22 had not been recertified in the use of the taser for several years, according to a review of records. They were also able to learn that the department's policy required training more often than that, but that had not, at least in this case, been followed. Appealing denials from a local law enforcement agency, sometimes they should go to the district attorney. This is Section 503D2 of the Right to Know law, that a district attorney shall designate one or more appeals officers to hear appeals relating to access to criminal investigative records of a local agency of that county. It only applies to denials based on 708B16. That's the criminal investigative exemption. That is the only one that this process applies to. However, if you mistakenly file with the Office of Open Records, we will review the filing. If the entire appeal needs to be transferred to the district attorney, or part of the appeal needs to be transferred to the district attorney, we will do that. We work very well with district attorney offices all over the state in doing this. Sometimes they transfer cases to us, we transfer cases to them. The goal is to get it to the right place and have the process work. Sometimes we have joint jurisdiction. A particular request might involve criminal investigative records and other records from the police department. And so sometimes the OOR has jurisdiction over part of the appeal. Sometimes the district attorney does. Again, if you appeal to the Office of Open Records, we are very happy to sort it out and make sure that things get where they're going to, things get to where they should be. We do hear all cases involving the Pennsylvania State Police. So if you have a case involving the state police and you want to file an appeal, that should come to the Office of Open Records. The Right to Know law does not apply to any police recordings, audio or video. That's covered by Act 22 of 2017. We have a page on our website that goes into great detail about Act 22, how to request records, how to appeal if you were denied, all of that sort of thing. Some of the highlights include the fact that you have to make a request within 60 days of the recording date. For the Right to Know law, it doesn't matter when you make the request. You can request records from the 1700s. If they exist, they're subject to the Right to Know law and all those exemptions. But if they exist, you may very well get them. For police video and police audio recordings, you have a 60-day time limit in which to make your request. The agency has 30 days to respond. Denials do not go to the Office of Open Records. They go directly to court, and there is a $125 fee for those. So it's a different appeal process. Now, law enforcement agencies and district attorneys can release these kinds of records with fairly broad discretion, with or without a written request. And again, we have more information about that law that governs access to police video and audio recordings on our website. 911 recordings and transcripts, those can be released, but it is entirely within the discretion of the agency to decide whether or not to do that. The law doesn't require them to release it. The law does not require them to withhold it. The decision is entirely within their discretion. A court can order the agency to release the records, but the Office of Open Records does not have that authority. Now, time response logs are public, not defined in the law, but they have been defined somewhat in case law. And it includes, at a minimum, location information, such as the mile marker, the block identifier, such as the 100 block of Pine Street, or the closest intersection, the closest cross street to where the incident happened. It should also include the date, the call time, dispatch time, all that sort of information. And the goal here, of course, is to let people review the efficiency of emergency response in their community. So time response logs are public. Call recordings and transcripts, that is entirely within the discretion of the agency. I mentioned this before, but I want to emphasize it again. Communicate with the agency. Good communication can solve a lot of issues under the right to know law. Always let the agency know you're willing to talk. Requesters often submit broad requests because they want this, right? They want a little bit of information, but they don't know how to specifically ask for that with absolute perfection. So they submit a much broader request. Very understandable, but it can be expensive. Communication can solve that problem. Many agencies are willing to discuss requests. Many are. Some are not, and that's okay. That's a way to approach things. But from our perspective, what we've seen time after time is that good communication between requesters and agencies goes a very long way to solving problems. Now, if during those discussions you reach some sort of agreement on a revised request, a revised deadline, anything of that sort, be sure to put it in writing. You want to be able to have something in writing, in email, that the Office of Open Records can review if you wind up having to file an appeal. An agency cannot require a requester to provide a reason that they're making the request. They can ask, but the requester can decline to answer, hopefully politely, but they can decline to answer. Sometimes, however, it makes sense for the requester to go ahead and provide that information. It can help the agency understand the request. It might speed up the response. It can reduce the number of worthless records that you wind up receiving in the end. And if hard copies have to be made, it can reduce the cost. But if for whatever reason you, the requester, don't want to give a reason, you don't have to. The agency can ask you, and it can be helpful to have that conversation, but it is not required on the part of the requester. Most denials, we've talked about this a few times, can be appealed to the Office of Open Records. Here I want to emphasize again, 15 business days. That's your deadline for filing an appeal. We are open 5 days a week, not including holidays, of course. But you have 15 business days. Those are Office of Open Records business days to file your appeal. Most appeals are filed with us. If you have made a request to one of the statewide row officers, such as the Attorney General, the Auditor General, or the Treasurer, if you've made a request to the General Assembly, if you've made a request to any of the courts in Pennsylvania, those appeals get filed elsewhere. The Attorney General, Auditor General, Treasurer, and General Assembly, those appeals get filed within those institutions themselves. Same with the courts. And we've talked about the local law enforcement agency situation with district attorneys. Remember that you can also appeal redactions. Redactions are a form of denial. So even if a single word is redacted in a 100-page document, if you think that word is important and you're not sure why it was redacted, or you don't think that the reason for redaction was proper under the right to know law, you can appeal that. You can also appeal any fees that an agency proposes to charge. So if an agency says, we have your records ready, that will be $42.50. You can appeal that if you don't think that their calculation on that fee was correct. Our appeal process is designed to be simple. I hope it is. If you run into problems, please let me know, because I want to make it simple. I think we've done a pretty good job of that. There's an online form at our website. Fill that out. That's the best way by far to file an appeal under the right to know law. It takes about 10 or 15 minutes to fill out. We've tried our best to make it foolproof so that you can, if you fill out that form, you will meet all of the legal and technical requirements for filing a right to know law appeal. You have to work really hard to mess up that form. You can do it, but it's not easy. All you need to do is complete that form. You don't need to send us any arguments. You don't need to send us any evidence. All you're doing up front is getting the appeal into the process. Once we receive the appeal, we send out a packet to both sides. It explains what's going to happen. It explains how you can submit evidence if you have any. It explains how you can submit argument if you want to. And it explains what's going to happen during the appeal process. Now, remember, going way back to the beginning of this discussion, that the agency bears the burden of proof. If they want to withhold records, they have to explain what law allows them to withhold the records. So we often have cases where requesters file an appeal, they fill out this form, 15 minutes, and they don't do anything else. And they win the case because agencies aren't always able to meet that burden of proof. So as the requester, you don't need a lawyer and you don't need to make arguments and present evidence. You are welcome to. And in some cases, it is very, very smart and very good to do that. And in some cases, you might want to have a lawyer representing you. But over 90% of the people who file appeals with the Office of Open Records, and that is not a database number, that's my impression based on studying the incoming cases, but 90% plus are not represented by attorneys. It is far less common for a requester to be represented by an attorney than to be acting on their own behalf. So we welcome your arguments, we all welcome your evidence, but it's not always necessary. This should not be an intimidating process, and we work very hard to try and make sure that it is not. When the appeal is filed, we assign an appeals officer to oversee the case. All of our appeals officers are attorneys. They act in a quasi-judicial role, so they're not representing one side or the other. They're acting as a kind of a judge who's going to make a decision on whether or not the records that are in dispute are public or not public. Both sides have a chance to present evidence and argument. In almost every case, the agency really needs to do that. Typically, they're going to present the evidence in the form of affidavits. This is almost always done exclusively by email back and forth. Both sides have that chance to present evidence and argument. The Office of Open Records, our appeals officers, we only have 30 days to issue a final determination. So it's December 2nd today. If an appeal comes in today, it's due on December 31st. And that's a very quick turnaround because both sides need to be able to present whatever it is they want to present to us. One of the questions you're asked when you fill out the appeal form is whether you're willing to give the Office of Open Records an extra 30 days to make a decision. If you can do that, please do. We totally understand that there are situations where timeliness is a factor and it's not always possible. But if you can do that, please do. And if during the course of an appeal, one of our appeals officers asks for more time, it's because they're digging into something in the case. They might want to get more evidence. We want to get the answer right. You know, our job is to develop the record and reach the right decision based on the law, based on precedent, etc. And to do that, sometimes we need a little bit more time. So if you're able to, please do grant any request along those lines. Here's what our appeal form looks like. Very simple. Some information about you at the top, some information about the agency comes next. We ask you to describe the records that are at issue in the appeal. That's all. Just describe what records you're appealing, you're filing this appeal about. Tell us a little bit about the way the request was submitted. That text in the blue box there is information that you're submitting this form basically saying that you believe that the response you received was not appropriate under the right to know law, and that's why you're filing the appeal. We allow you to attach files. There are a number of checkboxes here. I talked about the one that allows you to grant the OOR an additional 30 days to issue a final determination. The others are really designed to walk you through the process of making sure your appeal is complete. We need a copy of the request that you sent in. We need a copy of all responses from the agency regarding that request. any notices or letters from the agency extending the time frame, that sort of stuff. So we put together this checklist to help make sure that everything you need to submit is being submitted. There's also a box there where you can check and say that you're interested in resolving the issue through mediation. We have a mediation program. It is very successful. When people go into OOR mediation, it typically works out, not always. It is entirely voluntary. It is a confidential process. The goal, of course, is to reach a mutually agreeable settlement. Either side can end mediation at any time. So if you agree to mediation and the agency agrees, but you get into that process and one side or the other feels like it's not being productive for whatever reason, you can say, thanks very much, OOR. We appreciate your efforts. We'd like to end mediation now. When that happens, the case simply moves back to the normal appeals process. And it goes to a different appeals officer. Some of our appeals officers are trained mediators, not all of them. And so if appeals officer A was involved in the mediation, when mediation ends, it's going to go over to appeals officer B. So it's a completely separate process. And what happened in mediation does not affect what's going to happen in that normal appeal process. It can save time and expense to do the mediation, because what happens at the end of mediation is that the case is over. The requester winds up withdrawing their appeal because they've received the records that they agreed would be acceptable in the mediation process. And that means neither side is going to go to court. There's no possibility that a successfully mediated case goes to court. So that's one of the main reasons that people like the mediation process. A little bit about the Office of Open Records. We decide appeals under the Right to Know law. We provide training on the Right to Know law and the Sunshine Act. We have a training calendar on our website where you can find all sorts of information about upcoming webinars. When in-person training becomes possible again, we look forward to doing that as well. We have 20 staff. That includes me. It includes the deputy director, 13 attorneys, 11 of whom are appeals officers. Our chief of training and outreach, George Spees, who's with me on today's webinar. And we also have an incredible team of 4 administrative staff who keep everything running on time. Our caseload every year, we get about 2,500 cases. Last year we had about 2,700. This year we're right in that range again, somewhere between 2,500 and 2,700. That is appeals. If you go back to the previous slide, you remember that we have 11 appeals officers. So 11 people are deciding 2,500 to 2,700 cases every year. It is a very busy office. The appeals officers do phenomenal work. I am in awe always and grateful always for the work they do. But that's just appeals. That's not requests. Across the state, there's not a central database that tracks this, but the Legislative Budget and Finance Committee did an outstanding study in 2018. They were looking at data from 2016. At that time, they estimated 109,000 requests were received by state and local agencies combined in 2016. So agency open records officers across the state also do a phenomenal job, by and large, of processing the incoming caseload of right to know requests. If you do the numbers, something like 2% of requests get appealed to the Office of Open Records. And again, our data indicates that fewer than 10% of our decisions are appealed to court. So in terms of the entire right to know universe, very few cases come to the OOR, and very much fewer, even than that, cases go to court past the OOR. Here are some resources for you to access involving the right to know law in the Office of Open Records. If you have any questions, please go ahead and type them into the chat now. I'd be very happy to stay and answer questions for as long as there are any. But check out our website. I encourage you, if you're interested in a specific kind of record, look at our Right to Know Law Case Law Index. It goes into each of those exemptions we talked about one by one. describes the cases, describes the outcome, gives links to the court decisions. So there's a lot of good information there. The Open Records in Pennsylvania blog, it includes COVID-19 advisories about the Right to Know law and the Sunshine Act. That's another resource of the Office of Open Records. We have email lists, general updates, which comes out periodically once every other week, sometimes more like once a month. But we also have a daily digest of our final determinations. So if you're really interested in Pennsylvania right to know law issues, sign up for that daily digest. It is one email. It comes out every morning, and it describes every case that the OOR decided the previous day. So you can really get a sense of what's going on in terms of right to know law appeals across the Commonwealth. We're on Twitter. I'm on Twitter at Erik Open Records, and very happy to have conversations on Twitter as well. So if you have a question that you think of later, feel free to hit me up on Twitter and ask it there. We have a YouTube channel. This video, I hope, will be up there within a day or two. We have all of our annual trainings there from recent years. We also have additional videos going into details about the right to know law and how to use it. We also have a podcast. It's been a little while since we've updated the podcast. I hope to get back to that soon, but it is there for those of you who like podcasts. And with that, it doesn't look like we have any questions right now. So please feel free to contact us. The Office of Open Records website has our contact information. Like I said, I'm on Twitter at Erik Open Records. I'm very happy to discuss things with you there. Thank you so much for attending this morning's webinar. I hope it was useful. Thank you for those kind words. I appreciate it. And have a great day, everybody. We will talk to you very soon.